The U.S. Supreme Court heard oral arguments in what potentially could be a pivotal case affecting parents and students in Montgomery County, Maryland. And experts argue that the case could actually have implications for parental rights nationwide. So, what are these legal implications? Will the Supreme Court take a stand for parents' rights? Critically important questions, and here now to share more is Daniel Schmid, who is Associate Vice President of Legal Affairs with Liberty Counsel. And Liberty Counsel filed an amicus brief, or a friend of the court brief, in favor of the parents that sued the school board. Daniel, welcome back to Washington Watch. It's great to have you.
Jody, it's nice to be back with you. Thank you for having me.
Well, listen, let's start with the overarching legal question that the justices were examining yesterday.
Well, the case hinges on whether a public school district who has decided to put forward a radical LGBT, transgender, really just a gross and obscene curriculum targeted at pre-kindergarten to fifth grade. And what used to be available to parents in the Montgomery County School District, they took away, which was the right to opt out and the right, shockingly, to even have notice of the issues that were going to be included in these books that were targeted by their own audience definitions to target 3-year-olds to 5-year-olds up to fourth grade. And the content of these books was just outlandish. A group of Jewish and Muslim parents sued, seeking under the First Amendment to have an opt-out. And the Montgomery County School District permits opt-outs for a whole host of other reasons. But when it came to this one curriculum where they wanted to radicalize the children and poison their minds, they took away the opt-out and took away the option to even notify the parents.
That is just, it's stunning to me to think that we are watching this kind of stuff here in the United States. So you mentioned some Jewish and Muslim parents. I go further into that. What do we know about these parents? Who are they? What is it that is moving them to sue the school board?
Well, they have sincere religious beliefs, as you can imagine, that encourage them and compel them. And it's not just Jewish and Muslim. There's a coalition of parents who have religious objections to a curriculum that sexualizes children. And these books they're set to cartoons and like a targeted audience, but the content of them, one of them called Pride Puppy, I'll just point out, it sends these kids on, they go to a pride parade, and the story is about these kids who are tasked with going out and finding underwear and leather straps and this famous drag queen and the drag king and all these other things, in addition to a whole host of other books that were in the curriculum. Well, the parents here, some of the Muslim faith, some of the Jewish faith, and others have sincere convictions based on the Bible and other of their religious texts that they don't want their children exposed to this. They want the option to opt them out of this particular curriculum so that their minds aren't poisoned by it. The First Amendment entitles them to that right. It affords them that right. Indeed, it was the premise of our country, the right to be free, and the freedom they sought was religious freedom. So the parents have sued seeking what used to be available to them, but was taken away for this curriculum, just to opt their children out so that they can continue to teach them in their religious convictions.
Okay, so that's very understandable where the parents are coming from, why they are upset, why they resent the fact that their rights as well as their religious beliefs are being trampled upon. So I get their argument. What, on the other hand, could the argument be from the Montgomery County Board of Education? What is their stance in all of this?
Astoundingly, and this is really shocking, they say because too many parents decided to opt out, it became unworkable for them to continue with their radical curriculum. So a whole host of parents including the religious ones who sued, but there were also others who aren't religious, but who don't think this type of content is appropriate for a pre-kindergartner, 3-year-old, 5-year-old. And so they opted out. They said, we no longer want our children exposed to this. And at that point, because so many had objected to this obscene curriculum, the school district said, well, this is unworkable. We can't have this many people opt out of it. So we'll just take away the opt-out. And the attorney for the school district stood up there yesterday in front of the 9 justices and said, the government has an interest in making sure that too many people don't opt out. Now, for those of us on the conservative side, one has to wonder, well, we're not targeting and being able to reach as many with our radical ideologies and indoctrinate them for the future generation. That's really what I think their interest is. But what they said was it was unmanageable. It was unworkable to accommodate your religious beliefs, so we're just not going to do it anymore.
Wow. I'm listening to you in virtual disbelief. I mean, my first question was, how many need to opt out before they recognize that what they're trying to push is contrary with what parents want? And even the arrogance to continue to force them to do what they don't want to do with their children is unbelievable. So let me just ask you, let's go back to your presence there, I mean, and watching all of this in the midst of it unfolding. Recap some of the arguments that were made that either on the positive side or the negative side that you think stuck.
I don't think there were many on the supportive side. Now the court breaks down, as we often think, along ideological lines. This one shouldn't be. I think based on the way the arguments went, the parents will prevail, and what has been recognized as the oldest fundamental right in our country, which is the right to direct the upbringing and education of your children, will be affirmed. The school district doesn't get to poison the children. And it doesn't matter whether you consider it a benefit or a public right or whatever. The states all have laws that compel students to be there. But just because a parent drops them off at public school doesn't make them a ward of the state. The state doesn't become the parent for 8 hours a day and get to indoctrinate them with whatever they want. But that's kind of where the questioning arose. So on the 3 liberal justice side, they had some questions as to, well, what's the problem with this curriculum? It's just teaching them that there are different types of people, that there are some people who have 2 dads and have 2 moms. And so why is that bad for the school to teach tolerance and to teach that there are different types of people in the community and you should be accepting of them? Well, putting aside the fact that that's not what the books teach, it doesn't matter. What the parents said, and this goes back to Obergefell, which was the case that purported to create a right to same-sex marriage, which is nowhere found in the Constitution. But even in that case, the court said there are a great many Americans who have religious beliefs that are opposed to this, and they will maintain the right to teach their children, to espouse those views, to do what the First Amendment says, which is to exercise those beliefs. It's not just a freedom to believe it. You get to exercise it in your daily life, including teaching your children. And so what the more conservative justices were asking was, well, how in the world do we get around our precedent that says you have the right to direct the upbringing and education of your children and just throw that out in the public school context? It doesn't work that way. Students don't shed their constitutional rights at the schoolhouse gate. We've known that for 70 years, as if we needed to know it for that long, but the Supreme Court articulated that in Tinker. It holds true today. And so that was the back and forth as to, well, shouldn't we just allow this to go forward? And if there's too many opt-outs, it becomes unworkable. And there are some children who are not taught this quote unquote tolerance regime. That's not what it's about. It's about indoctrination and the future generation. But that was the liberal side of the coin. And the conservative side of the coin was, how in the world does this pass what we call strict scrutiny, which is the most demanding test known to constitutional law? And it compels the government to satisfy a very demanding burden when it seeks to infringe the religious beliefs of parents or religious adherents. And a lot of the conservative justices thought, there's no way this satisfies it. You have no compelling interest in indoctrinating pre-kindergartners with this radical gender nonsense that defies biological reality. It defies what human nature has known since the beginning of creation, that there are two genders. We now have an executive order that says that. One wouldn't think you'd need an executive order from the White House to suggest what
That's
biological reality holds, but nevertheless, here we are. And the court said, you have no compelling interest in mandating that to these children. And so I think it went well. I think the back and forth was as expected between the two sides, if you will. But I think ultimately the parents will prevail and their right to religious freedom will be upheld.
Excellent news. Daniel Schmid, Liberty Counsel, I want to thank you so much for sharing your legal analysis in all of this. Absolutely fascinating, extremely important case. Thank you for joining us today on Washington Watch.